Welcome, everybody. This is the Coimbra Law blog, bLAWG, bLAWgcast, and just want to discuss some important issues that affect your lives, everyone's lives. You know, when most people think of a criminal lawyer or a lawyer generally, they think, well, I don't really have to deal with that issue now. I'm not the type to ever get arrested. I'm not the type to really get involved in lawsuits. But the truth of the matter is that the law will kind of slap you in the face. A lot of things that you may not believe are illegal right now. You might be violating the law in some way you don't know. You might be confronting a situation you never imagined or dreamed of. It could be something as easy as a police stop. You might have a police officer who you don't see eye to eye with, and then things escalate from a disagreement into an altercation that involves you getting tased or involves you getting beaten. Certainly, hundreds of thousands of Americans have not been strangers to this situation, as we've seen from the highly publicized incidents of police brutality, outright murder of civilians in the Eric Garner case and Michael Brown, and just the stories are legion. I'm not going to get into all of them right now, but just by way of introduction, I'm an award-winning criminal trial lawyer. I've got many years of experience, and I've represented tens upon thousands of people facing really dire, ugly situations. Regular people just who somehow or another become ensnared in issues that they never, thought were imaginable. Many of those people were factually innocent, and through mistaken identity or through a false allegation from somebody who had a vendetta against the person, they just ended up confronting, either a civil suit, a criminal suit, or were on the suing end of a civil suit to try to vindicate their rights. Okay, so we're going to get right to it. A lot of things going on in the headlines lately. More recently, we've had the U.S. Supreme Court making a very important ruling, and of course a lot of these rulings have gotten lost in the bigger headlines. Obviously there was a huge triumph for same-sex couples and equal protection being extended to same-sex marriages. While that's great and laudable, there are other things that also need to be pointed out that directly affect your everyday lives. And one of them is a case called Kingsley versus Hendrickson. Kingsley versus Hendrickson. It's out of the Fourth Circuit Court of Appeals. And basically the Supreme Court said as follows. First, I'm going to give you a little background. The main issue is this. There was a gentleman named Kingsley, last name Kingsley. He was a detainee in a county jail. I believe this happened in North Carolina. He was awaiting trial, like millions of Americans caught up in the criminal justice system. They're arrested, arraigned, and then, of course, they're awaiting trial or pre-trial. Well, this gentleman was not yet sentenced to anything. He was awaiting trial. And what happened was he claimed that the police had forcibly beaten and stunned him with a taser because he allegedly did not comply with one of with an instruction issued to him by a police officer. This was happening while he was being moved to a holding cell. Anyway, that's the background. Kingsley later went on to sue the prison officials, and he said that his due process rights under the 14th Amendment were violated and that they used excessive force. So here's what happened. The problem with Kingsley's case was this. At the time, before the Supreme Court ruled the way it did, in order for him to prove up an excessive force case, he had to show that the police officers subjectively believed that, or they subjectively should have known better. What does that mean? What does subjective mean in this context? It means that if you were to ask the police officers, they could virtually say, well, I don't think that the way I acted was unreasonable. The guy wasn't complying. I tased him because he wasn't listening to my orders. What else could I do? Obviously, that type of standard of proof makes it easier for cops to get away with all manners of abuse. At least that was the case in the Fourth Circuit, which encompasses North Carolina and the adjacent states. So if you live there and you get beat up by a cop, and basically all the cop has to do is testify, for all intents and purposes, that he didn't think he did anything wrong, and if a jury concurs with that, then that's good enough. Well, obviously, if you're on the plaintiff side of that and you've gotten beaten up by the police, that's a pretty, you might think that's a pretty easy way for a cop to get away with excessive force. So luckily the Supreme Court stepped in and they said, well, it shouldn't be that simple, so we're going to apply an objective standard, meaning a reasonable person in the shoes of the police officer should have known that he was acting with excessive force. Okay, obviously that is a huge win for people who have been brutalized by the police and who want to initiate a civil suit, at least in the Fourth Circuit, but also other parts of the country. The lawyers are going to start using this argument more and more. At least in the Fourth Circuit Court of Appeals, it's going to be a heck of a lot easier to prove that, and of course it's going to put cops on the defensive. For example, they're going to have to probably revise all their procedures. They're going to have to get more insurance. They're going to have to get added training and facilities. So it's going to make it harder for the police to defend these suits, which hopefully means there's going to be an incentive for the police to think things through a little more every time they're confronted with a situation that they think they have to use deadly force or excessive force. They're going to have to sort of step back from the situation, think things out a little more, and see if they can resolve it without applying so much force. There's another great Supreme Court decision, at least if you're a prosecutor, not so great if you're obviously on the defense side. And we're talking about a case called North Dakota versus Wynn. That's Nguyen. A gentleman named Matthew Wynn. Just to give you a little background. Essentially, what happened was we have a guy who rents an apartment in an apartment complex. And the police were called to that area. They had police dogs, and they the police dogs, or police dog, conducted what's called a sniff search, and he sniffed out the canine sniffed out marijuana, and so they arrested this guy for possession of marijuana with intent to deliver. That is how they based the search, is through this initial sniff search. Okay, so anyway, what happened was, as he was being prosecuted, his attorney filed a motion to suppress evidence. And just as a brief background, that's a legal instrument that attorneys file if you've got a case against you and you think the police violated your rights in acquiring the evidence against you, just like this, a drug search, for example, or a sniff search. And they didn't do it with a warrant, or they didn't have probable cause where they didn't need a warrant, or they didn't have any sort of exception, and they're using that evidence against you. Your lawyer can ask the court, and the court pretty much has to throw the evidence out. It's a great way to get rid of a drug case where the police overstep their bounds, because, well, drug cases rely on evidence they recover from a home or vehicle. In any event, Matthew Wynn, the guy who was challenging the search, the guy who was the defendant in this possession with intent to sell case, he prevailed. The court said, yeah, that's unconstitutional. Without a warrant, the police didn't really have a right to basically sniff outside of, or the police dog couldn't sniff outside of his apartment and then use that to procure a warrant or otherwise, bust the guy for drugs. Well, the prosecutor took issue with that decision, obviously, because that means the case basically disappears once there's no evidence, because the police overstepped their bounds and they've got no more case. That didn't make the prosecutor very happy, and the prosecutor appealed the favorable defense motion to suppress, and the prosecutor won. And the court said the following: why did they win? Why would that be the case? Don't you think that it's kind of intrusive for the police to simply walk around with a canine and start sniffing out people's doors to sniff out marijuana, and then on that basis you'd start busting just about, well, a lot of people. A lot of people, use marijuana medicinally or recreationally, and in some states that's perfectly legal. Personally, I think that is invasive. Other people might not agree. Well, the one of the people who didn't agree were the justices at the appellate court in North Dakota, which sided with the prosecution. And here is their reasoning. Basically, they said that a rental situation, and this guy was renting an apartment, is very different from somebody who owns a home. Now, you might think that that's pretty unfair, discriminates between homeowners and renters. However, what the court made an emphasis or made a point on is that the renter shares the hallway with other renters. A homeowner doesn't necessarily have that situation. Therefore, he does not have the same expectation of ownership as a homeowner. So the next step would have been, and it was, the defendant here, Mr. Wynn, and his attorney to take this unfavorable decision to the Supreme Court, where they would have applied the Fourth Amendment, so on and so forth, and possibly reverse the prosecutor's favorable decision and then get the case thrown out again. Well, that did not happen. In fact, the court declined to hear the case. And what happens when the Supreme Court declines to hear a case? Well, you have to understand they receive about 10,000 requests every year, and it really only hears about 75 to 80 cases out of all those 10,000. Well, this is one of the cases that did not make it, and what the significance of that is that the prosecutors, let me backtrack, the decision of the North Dakota Supreme Court to uphold, the decision of the decision of the North Dakota Supreme Court to basically overturn the decision of the lower court stands. So Mr. Wynn is pretty much SOL, he's out of luck. Initially, he had a favorable ruling from the trial court. The North Dakota Supreme Court disagreed with that, and then the bottom line is this: if you're in that jurisdiction, guess what? The police do not need a warrant to have a police dog walk up to your door, and if you're a renter, I'm sorry, but it's certainly not a good situation in that jurisdiction for the reasons that the North Dakota Supreme Court articulated. This next case is the type of ruling that I love, because I am a huge proponent of the First Amendment and free speech. It's what makes our country such a magnificent temple of democracy that we are, except for very select few purposes, and I'm sure a lot of more cynical people out there would disagree with me, but it is the right that has weathered many storms by many despotic, oppressive personalities who would like to see certain forms of speech banned. I think that type of attitude is just repulsive. I think what makes the United States unique among the Western democracies is that no matter how repulsive, no matter how repellent speech or certain types of speech might be to certain sensibilities, that is your ability to speak freely regarding any subject is a protected right. And imagine if that weren't the case, if the courts, and of course, I understand they already do in certain very limited circumstances, and there are time, speech, and manner, protections, or not protections, but limitations on it. But generally speaking, no matter how repellent your ideas or what you promote or promulgate, generally speaking, the First Amendment protects your ability to, spout whatever you want to spout. If that weren't the case, imagine, what a hell it would be that you basically have to walk on eggshells, and a lot of people would probably agree when I say you kind of already have to do that as is, but at least you don't have to worry about the police coming to knock down your door because you uttered something unpopular. Anyway, with all that said, Here is a case that upholds the First Amendment, and I commend the Washington Supreme Court for doing so. Anyway, what happened is this. We have a situation, we've got a juvenile girl, only known or identified by the initials of EJJ. And you've probably, if you've ever been arrested or you've encountered something like this, either somebody you knew was getting arrested and you wanted to utter every name in the book, and excuse my language, but fuck you, fuck the police, whatever. People have very colorful ways of hurling insults at others, including the police, in a desperate situation like that. Anyway, so what happened was EJJ was witnessing her sister getting arrested, and she thought that one of the police officers was about to pull out a nightstick and start beating up her sister. And actually, let me backtrack. EJJ is a male. I don't want there to be any confusion. It's a he. So anyway, EJJ was standing out in the doorway watching all of this happen, and then he yelled at the police officers not to use the nightstick on his sister. The cop said, no, you got to get back in the house, close the door, you're obstructing, whatever. You're getting in the way of our job. I'm, of course, paraphrasing, not necessarily what they said exactly, but effectively they were telling him to get back in the house and just stay away, don't interfere. While all this was happening, he was yelling profanities. And ultimately, I guess the police got frustrated and they arrested not only his sister, but they also arrested him on a charge of obstructing a law enforcement officer. In California, we have a similar statute. It's also known as resisting arrest. So anyway, what happened was EJJ, now we're just focusing on EJJ, not his sister and what happened to her. He got prosecuted for saying things, for uttering insults, for using his mouth to voice an objection. Now, don't you think that regardless of the situation, I'm going to play devil's advocate for a second first. Let's say, I guess if you're the prosecution or you're in favor of the police arresting someone who's hurling insults at the police officer, you'd say, well, yeah, because this person should be prosecuted. There ought to be a law that restrains or punishes somebody from doing so, because otherwise they're interfering with police work. And I'm not an unreasonable person. I guess I can see their point. But if you really measure that up against the First Amendment, if you measure that up against the right of somebody to utter his or her beliefs, or even in a situation as uncomfortable as an arrest, is something that could really in certain instances has turned fatal. It turns into a fatal altercation. The Washington Supreme Court said, look, you can't lock somebody up for insulting the cops or calling them abusive names or yelling profanity. You just can't do it. And I think what was happening here was that the prosecution and the police were hiding behind the obstruction of a law enforcement officer as a crime to try to punish this person for their speech. So the Washington Supreme Court said, no, you can't do that. We are going to uphold this person's First Amendment right, and that First Amendment right protects this person and all citizens falling under this jurisdiction, protects that person essentially from criminal prosecution against or for hurling insults at the police. So anyway, I think that's a great victory for the First Amendment. It's a great victory for free speech. It's obviously going to have limited applicability. It's not the U.S. Supreme Court did not make the ruling, and so therefore, if you're in California and and I practice law in California. My firm represents clients in California. If you are in California, You cannot, if you are busted for the same thing, if you're busted for resisting arrest and it's largely on the basis of some profanities that you yelled at the cops, could have been at a demonstration, at a protest, or witnessing someone getting arrested, or you were getting arrested, and you get prosecuted for this, your lawyer, if you get a good lawyer who knows his stuff, knows his constitutional law, and God knows we follow case authority as it comes down on a daily basis, especially with constitutional law issues. If you get somebody like one of our attorneys, you can bet we're going to use this case to get your case thrown out. But understand that this case has limited application because it would be considered persuasive authority and not mandatory authority. There's a really big difference between case authority that's mandatory and persuasive. If it were a U.S. Supreme Court case, or if it were a California Supreme Court case, or if it were a U.S. Ninth Circuit Court of Appeals federal case affecting the Ninth Circuit, and California is part of the Ninth Circuit, then it would probably have mandatory application in all situations. But this is a state court case limited to the jurisdiction of Washington State, meaning while your lawyer can use it to try to convince the judge is not required to follow this case. You certainly have the right to bring it to the judge's attention, and the judge might say, well, yeah, I mean, that makes sense to me, I'll apply it here. He's certainly not required to do so. That's the difference between persuasive and mandatory authority. The next and final case we're going to be reviewing today is not really a case that the Supreme Court, for example, has already ruled, but they might be taking the case quite soon, and they could change the landscape with respect to the issue of concealed carry permits. And the common cynical view of the situation, of course, and it's rooted in fact, is that the LA County sheriffs or the San Diego sheriffs or other city or municipal police agencies, sheriff's departments are just unwilling to allow people to have concealed carry permits to carry a firearm with you in a concealed basis, because California, of course, is not an open carry state. And obviously, this is very unfortunate for people who really run a high risk through their occupation or through some personal situation that they've had to carry a firearm to defend their lives. And short of producing, an ongoing restraining order or some other document proving that the person who is petitioning for the concealed carry permit, that their life is in like some sort of immediate, imminent danger, these county sheriffs just will not issue these permits. I personally think, and as a lawyer, I think that approach is just it so runs afoul of the Constitution, regardless of your political leaning one way or the other. But especially if you believe in gun control, I think that runs so contrary to established law. We had a case that the U.S. Supreme Court decided in 2008, Heller versus D.C., where Washington, D.C., their local government essentially banned a certain type of firearm. I think they just banned firearms, at least in that area, handguns. And the the opponent of this was a person last name Heller. They took it up to the U.S. Supreme Court, and they said that's absolutely unacceptable because it runs afoul of the Second Amendment, which protects our right to bear arms. And just because it's a state or local government, they cannot restrict that right because it is constitutionally guaranteed. And Heller enunciated this. So to have a stubborn regional government agency not follow the law obviously is incredibly frustrating if you're a gun owner. And here the gun owner is a person named Peruta, P-E-R-U-T-A, and they're suing San Diego County. They've been locked in litigation for some time now. And it was actually brought by the California Rifle and Pistol Association Foundation. And in that case, the conflict is between the firearm owner who wants the weapon for their own personal use, and the San Diego County sheriffs, who had just not been budging except for the most extreme circumstances, which again, I think violates the Constitution. Anyway, if the Supreme Court hears this case and rules consistently with Heller, they could be, they could deviate from that. I'm sure they can find some legal grounds to do that. I think it would have to be convoluted, because it really would be inconsistent with the Second Amendment. If they say that, if they end up ruling that Peruta can own this firearm and that these local restrictions are unconstitutional, I don't know what's going to become of the California approach. I don't know what's going to become of the argument made by gun control activists that a person's right to carry a concealed weapon and a person's right to obtain a permit should be highly restricted. I think, as it is, I think that approach is unconstitutional. If the Supreme Court gets a hold of this case and rules in favor of the plaintiff, it's going to be a landmark case, and a lot more people are going to be able to own firearms. Is that a good thing societally? I don't know. I'm speaking only as a constitutional law lawyer. I have my own political leanings on this, but I'm not touching on those. I am concentrating on what the law says. This could really shake the landscape. It could really shake the legal foundations of opposition to concealed carry permits, and it could really strip away a lot of those unconstitutional restrictions. Anyway, I hope you've enjoyed this first of hopefully many, many podcasts to come. Thanks for being part of Coimbra Law bLAWgcast. If you or a loved one is in need of an attorney who takes a pit bullish attitude and at fighting injustice, at fighting an unlawful arrest, we are the go-to firm. If you want more information, more literature to read about us and our work, and just a great encyclopedia of California criminal law and constitutional law literature, we're a click away at CoimbraLaw.com. COIM as in Mary, B as in boy, RALAW.com. And a whole world of information and interesting literature awaits you, covering all kinds of areas of the law. There's even a short story called The City, which is it takes a very entertaining approach to understanding the way that the criminal justice system works. Anyway, I am signing out, and hope to be publishing the next podcast very soon. Take care.